Hey, Marcus,
Yes.
while we're waiting here, check your email this afternoon or tomorrow, because we'll send you a Word document of the journal entries that you need to sign.
Can I let you know if I agree with it, where you can just e-sign it for me?
We can do that.
Okay, I did that with another one of my cases. So.
And that's fine. Do you just want me to e-sign it for you?
I'll look it over and then just put a thumbs up that is good.
Okay. Okay, we'll do that.
Okay.
We'll do that.
All right. Let's be on the record in case number 2019-CR1200, captioned State of Kansas versus Brandon Hnderson. Would the parties announce their appearances, please?
Yes, Your Honor. Christopher Schneider, Assistant District Attorney, appears on behalf of the state of Kansas.
May it please the court, Brandon Hnderson appears in custody via Zoom by counsel Marcus McLaughlin, who also appears via Zoom.
All right. And I
Your Honor.
Yeah, we're also calling case number 2012-CR1647 with the same caption and the same party appearances. As the lawyers mentioned, we are doing this by video conference. And Mr. Hnderson, during this pandemic, we're trying to do everything as safely for defendants and lawyers as we can. And part of that's doing what hearings we can by video conference. My understanding is you had a chance to talk to Mr. McLaughlin about this, and you're okay with proceeding by video conference and waiving personal appearance in court today. Is that correct?
Yes, sir.
All right, fantastic. All right, so in the 2019 case, we are here set down for sentencing. I would note for the record that back on May 26th, also by video conference, the parties appeared in front of the court, and at that time, the defendant changed his plea from one of not guilty to guilty. The court inquired and accepted that plea, ordered a pre-sentence investigation, and set sentencing over for today. I've received that PSI. The critical findings are as follows. The sole count of conviction in this case is one of violation of Offender Registration Act. That is a severity level 6. It says person felony. Mr. Schneider, is that a non-person felony?
Just a moment, Your Honor. Let me double check.
Yeah.
No, Your Honor, it's a person felony. The underlying offense that gave rise to the need to register is aggravated assault with a deadly weapon.
Okay. All right. I stand corrected. I thought it was on a non-person. So it's a severity level 6 person felony. The defendant's criminal history score was found to be that of G. That would leave him in a border box with a presumed range of 22, 24, or 26 months. It does show that there's a special rule number 9, which is a crime committed while on felony probation, which would destroy, which would make it without a presumption. However, there's also another special rule not noted in the pre-sentence investigation. That's number 46, and this is the Kansas Offender Registration Act special rule that says a conviction for this, the court can impose an optional non-prison sentence. I'm sorry, it's presumed imprisonment, but the court under certain findings can impose an optional non-prison sentence. So I'm going to orally amend the PSI to add special rule number 46 as well. If the defendant has to do this time, he's eligible to up to 15% good time credit and subject to a post-release supervision duration of 24 months. If he was granted probation today, it would be a period of 24 months to community corrections. Mr. Schneider, with that one oral amendment that I just made, do you have any other additions, corrections, or challenges to the findings of the pre-sentence investigation?
No, Your Honor.
Mr. McLaughlin, same question.
No, Your Honor.
All right. Mr. Hnderson, what your lawyer basically is telling me by that is that he went over this PSI with you. I'll hold it up here. It's not showing up. And specifically in the criminal history scoring, in the back, there's a worksheet where they talk about all your prior convictions, and it shows that you're a criminal history G. Mr. McLaughlin is telling me he went over that with you and that you don't have any objections or challenges to that. Is that correct?
Yes, sir. That's correct.
All right. I will adopt the findings with that one oral amendment, adding special rule 46 for today's purposes. Mr. McLaughlin, you filed a motion for departure. Would you like to be heard on that today?
Yes, Your Honor. In regards to this case, Mr. Henderson, the standard is 24 months, the mitigated is 22 months. However, in this particular case, I believe there are findings that would warrant a lowering of that 24 months. Mr. Henderson has always acknowledged his wrongs. He understands what he did wrong. He did waive preliminary hearing, saving the court and the state time and valuable resources in this particular case. Also, I do believe that it is within the plea with the state, Mr. Schneider, that this case would be lowered to 13 months. And that is my comment.
All right. Mr. Schneider, I would hear your comments as to the motion for departure. Any other items regarding this sentencing?
Judge, I would ask you to grant the motion for departure pursuant to the plea agreement in this case. I would also ask the court to follow the plea agreement in this case.
All right. Mr. McLaughlin, anything else regarding sentencing comment-wise?
No, Your Honor.
All right. Mr. Henderson, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
Well, I would just like to apologize to you and the court for my lack of responsibility and what I'm taking a plea for.
All right.
And just accepting my responsibility and let you know that I would like a chance to prove that I do belong in society and I'm not a threat to society, nor am I a threat to my community.
All righty. Thank you, Mr. Henderson. Mr. McLaughlin, do you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. I will follow the plea agreement and grant the downward durational departure motion to 13 months. I will adopt as the substantial and compelling reasons for that departure those set out in the defendant's motion and in his defense counsel's comments today. The defendant is not applying for probation. I do not believe that probation is appropriate in this case, and therefore he will not be granted probation. He will be eligible to up to 15% good time credit on this charge and subject to post-release supervision duration of 24 months. Do we know how much jail time credit Mr. Henderson has?
Judge, he has from January 22nd of this year.
All right.
So just a bit over 5 months.
All right. He'll be granted that jail time credit. You agree with that, Mr. McLaughlin?
Yes, Your Honor.
All right. Also, per the plea agreement, the defendant is already stipulated to revocation in 2012 CR 1647. I will find that the state has established those violations, and as a sanction, I'm going to modify that sentence in order that the 2 counts therein be modified to run concurrently with one another, leaving him with a controlling sentence of 13 months. By operation of law, this sentence must run consecutively to that sentence, and it is so ordered that it does so. All right, let me go over a couple of other things. Mr. Henderson, it sounds like you have 6 months or so in this case. Do you remember how much jail time credit you had in your old case?
Well, the CR 1647, I only served 1 day.
Okay.
So
how about the 2012 case? Any idea?
that's the 2012 case.
Okay.
Yes, sir.
All right. Oh, yeah. Okay. All right. Well, so it looks like you owe us about 20 months and you're going to get 15% off of that or so. So just under that, do you have a plan for when you get out, what you're gonna do?
Yes, sir.
What are you gonna do?
Well, my stepdad, he owns a trucking business. He's gonna pay for me to go to school so I can get my CDL, and I'm gonna immediately start working for him, driving dump trucks.
Fantastic. Sounds like a good job. All
Yes,
right.
sir.
All right. Well, then I think that the defendant will be able to meet his financial obligations. I'm going to assess court costs and supervision fee. Mr. McLaughlin, do you know what your attorney fees are going to be?
I have not added it up for the different cases yet, Your Honor.
All right.
Judge,
I'm only going to impose $150. I don't want to put him all the way behind the barrel here. I'm only going to, I'm assuming that they're much more voluminous than that. Is that correct, Mr. McLaughlin?
It is, Your Honor.
All right. I'll only assess 150 of that. He's already had the bids fee assessed.
Judge,
That KBI database fee, he's already in the system, so he doesn't need to pay that. I'm not ordering any fine in this case. That should cover the cost. Mr. Schneider, did you have something to say about that?
yeah, Judge, you talked about the correctional supervision fee. Since he's not being placed on supervision, that fee would not apply.
That's correct. I'm sorry, Mr. Schneider. I missed that. So supervision fee is not appropriate in this case as he's not being granted probation. Okay. Look, I don't expect that in the short time that Mr. Henderson is going to be in prison, that he's going to be able to make any real payments towards those. So I'm not ordering him to pay these fees while in prison, but upon the release, his release from prison. And I think he should be able to pay, oh, let's see, 150 to $100 a month and be able to have it all behind him before his post-release supervision is up. So my order will be $100 a month upon release from prison. Okay, a couple of things, Mr. Henderson. You have 14 days from today to appeal anything you don't like about the sentence that you just received. You also might be able to seek expungement of this conviction after a period of time following successful completion of supervision. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically any knives that could be considered a deadly weapon. The important point is before you decide to own or possess any kind of weapons like that, make sure you talk to a good lawyer like Mr. McLaughlin to make sure that it wouldn't be reason to revoke your post-release supervision or add new charges, okay?
Yes, sir.
All right. This is not a registration offense, Mr. Henderson, but you still have to register on those underlying offenses, okay?
Yes, sir.
To me, I really hate these cases because they seem like a really silly way to A, end up in prison, B, to make your criminal history look worse and all of that stuff. So you just, and I don't think it was, in this case anyway, motivated by hiding from anybody or trying, I just don't think you got around to doing it. And it's got really serious consequences when you don't do that, okay?
Yeah. Yes,
So
sir.
when you get out, I want you, within 3 days of that, wherever you move back to, whether it's Wyandotte County or somewhere else, get down to the sheriff's office, get yourself registered and meet that requirement so we don't ever have to do this silliness again, okay?
Yes, sir. You don't have to worry about that, Your Honor.
I'm glad to hear that, Brandon. I think you're going to do well. All right. Mr. McLaughlin, anything I failed to cover today?
Not that I can think of, Your Honor.
Mr. Schneider?
Nothing but the state, Judge.
Ms. Williams? Okay, I'm going to fill out all this commitment paperwork. I don't have anything. I'm not sure who his probation officer was, but I will get a, I need to get a commitment on that one too. And then Chris, you're gonna complete the journal entries of revocation and sentencing, get Mr. McLaughlin's approval, and then what, e-file them?
Well, if Marcus said it would, if he looked at it and gave you the thumbs up, we could apply his e-signature as well. So we'll do that. And then once that's done, and we'll try to get those to him this afternoon.
Awesome.
Once that's done, we will e-file them. So
Fantastic.
hopefully we can have that done by Monday.
Good deal. All right.
Can I say something?
Anything further for our record today?
I have one question, please, Your Honor.
Yes, sir.
So what is my actual sentence?
Your underlying sentence is 26 months. That's 13 in the old case, 13 in the new case. You're going to get credit for all the time that you've been in jail on those two cases.
Yes,
And
sir.
you can earn 15% good time credit once you get to DOC. So if you were to earn all your good time credit, I would guess you're looking at a year and a half.
Yes, sir.
That's a ballpark. Don't get up there and go, well, the judge says it's a year and a half. I just kind of
No, I-
ballparked you, okay?
Yes, sir.
All right, Mr. McLaughlin, you think I'm pretty accurate on that?
Yes, Your Honor.
Yeah, I think so too. Okay, all right,
And I-
anything else?
I'll have to do parole too.
Yeah, you got post-release supervision, which is what they call parole now for 2 years.
Yes, sir.
All right, fantastic. We are adjourned. Good luck to you, Mr. Henderson.
Thank you, Your Honor.